Hi guys, I'm Rahul, and I'm a recent law school graduate. I was intrigued when I heard that there was technological advancements in the legal field. Artificial intelligence that operates on a global legal platform. First thing I thought was wow. Second thing I thought was what's it gonna do? Is it trustable? And how are privacy laws in countries around the world? So my topic of discussion is privacy and the implications of unlawful access to private information in the legal industry. Problem happening around the world today is cybercrime. Symantec predicted in 2018 cybercriminals will increasingly use artificial intelligence and machine learning to conduct attacks. Serious security breach could lead to serious unlawful access to information, someone else's private and confidential information. Lawyers need to be on guard with the privacy laws for the jurisdiction they're working in. Lawyers are dealing with private and confidential information that belongs to their clients. So the privacy concerns in the legal field are a growing global concern.
The concept of privacy is legislated by the Commonwealth of Australia in the Privacy Act 1988. Personal information discussed by the full court of the Federal Court of Australia in the Privacy Commission Telstra Corporation. The court here dealt with the issue of whether mobile network data held by Telstra in relation to Mr. Grubb's mobile service is personal information, and that was determined on whether Mr. Grubb's identity is apparent or can reasonably be ascertained from the mobile network data. The court said that the personal information in relation to the Privacy Act is information of an opinion, whether true or not, and whether recorded in the material form or not, about an individual whose identity is apparent and and can reasonably be ascertained from the information. Personal information is constrained by 1, it must be held by the organization, 2, it must be about the individual who requested access, and 3, it must be about the individual whose identity is apparent or can be reasonably ascertained. The court said that the words about an individual require the court to determine whether the information itself forms an opinion to the identity of the person information belongs to. What's interesting here is that the court could not order Telstra to hand over to Mr. Grubbs the metadata. And the funny part is metadata is not even mentioned in the Privacy Act. So that means in Australia, I don't have access to metadata that companies are holding about me.
So what happens if there's a cyber attack and someone in another part of the world gets my personal information? In the case of X and Twitter, there was a defamation tweet from someone outside of Australia regarding financial information that didn't belong to the person making the comments. The Supreme Court of the New South Wales issued an injunction, as the primary relief sought against the defendant includes injunctions intended to restrain their conduct outside Australia. The court in X and Twitter relied on Humane Society International and Kyoto Sinpaku Kaisho Limited, which said that parties out of jurisdiction have been subjected to an injunction regarding their conduct abroad. If a person is properly served in accordance to the court's exorbitant jurisdiction, that person is in the same position as the person who is within the territorial jurisdiction. So that means if the person lives in a country where it's a crime to publish somebody else's personal information, the injunction applies to them and they're in the court's territory. But in relation to someone who lives in, say, a country like Mongolia who has an unfettered right to publish such information, the court in X and Twitter said that the injunction would exceed the proper limits if it made an injunction to interfere with that right. In the European Union, the concept of privacy is considered a fundamental human right. In the European Convention on Human Rights, Article 8, Clause 1, it says everyone has a right to respect of his private and family life, his home, and his correspondence. The second clause says that there shall be no interference by a public authority with the exercise of this right except in accordance with the law and is necessary in a democratic society. Privacy is even regulated data in the European Union's Charter of Fundamental Rights. Article 7 says that everyone has the right to respect for his or her private and family life, home, and communication. But here's where the EU differs from Australia. In Article 8, Clause 1, everyone has a right to the protection of personal data concerning him or her. For data to be processed, Clause 2 requires consent from the person concerned. To add, everyone has a right to access data which has been collected concerning him or her and to have it rectified. This is a big change compared to Australia, because in the European Union, individuals have a right to access data that concerns them, even metadata. The General Data Protection Regulation, or the GDPR, came into force May 2018. The GDPR regulates personal data breaches. According to Article 4, Number 12 of the GDPR, personal data breach is a breach of security leading to accidental unlawful access to personal data transmitted, stored, or otherwise processed. Article 51 requires the controller to notify the supervisory authority without undue delay and within 72 hours of the personal data breach. Puts an obligation on the supervisory authorities to protect the rights and freedoms of the data subject by way of better level of transparency. The GDPR regulates the right to access for individuals in the European Union. It gives the data subject the possibility to demand more in-depth information on processing in order to permit it to further assess the lawfulness of processing. Under Articles 13 and 14 of the GDPR, the right of access shall go beyond the data subject with general information on processing data activities. Article 15 sets the scope for right of access. The first step requires the data subject has the right to obtain information from the controller as to whether or not its personal data is being processed. Step 2 says that the data subject will have access to the person's data processed and the following: purposes of process, categories of personal data concern, recipients of the data, storage period, and the right to lodge a complaint, just to name a few. In 2014, in the case of A and British Broadcasting Corporation, BBC tried to appeal the court's decision to approve an anonymity injunction. An anonymity injunction was already granted to keep A's identity secret because he was being deported to his country of origin. A was charged for sexual assault and was served with a notice to deport. The danger was that if he was publicly known as a sexual offender, he would have been at risk of death or ill treatment in his country of origin. The wife and child had been attacked in Scotland in 2006 outside of a park. The court ruled that because there was evidence of violence and the risk of violence A faced in his country of origin, permitted circumstances for continuance of his anonymity order. Anonymity injunctions restrain a person from publishing information which concerns the applicant and is said to be confidential or private where the names of either or both of the parties to the proceedings is not stated. They add another layer of protection by ordering the very existence of the injunction to be kept secret. The court in ZAM and CFW said that these anonymity injunctions are rarely granted in breach of confidence and privacy causes of action. The current scheme that Australia has legislated for privacy is not ideal to protect a legal practitioner from a personal data breach. Australia should try and fall in line their privacy scheme with European unions, as they consider privacy to be a fundamental human right. However, cybercrime is happening all over the world. There's no adequate measures in place to prevent someone from a country like Mongolia from publishing someone else's personal information. And for that, I conclude that privacy laws are not adequate for a legal practitioner to disregard privacy as a major global issue when using the new artificial intelligence global legal platforms.